All right, welcome and thanks so much for joining us. My name is Liz Smith, and today I am going to cover an introduction, who I am, ask if you want to share anything about yourself, talk about what's some good reasons to be here, and if you want to share any others. Then we'll cover what would happen to your stuff when you die. That's going to mean what the state's plan is for you if you have no action at all, or take no action if you have no plan in place. We'll talk about probate and what that is and why you may still go through probate even if you've done some planning. We'll cover some of the basic tools, including a will, living trust, and other documents. When we talk about estate planning, it's really a comprehensive, it's not just the will or the trust. So I'll cover some of the other things you want to think about, including incapacity. Then I'll share some free tools with you, discuss when you might want to talk to a lawyer, and open it up for any questions. Again, we'll have plenty of time for questions at the end, and I welcome any questions during the presentation using the chat box. Before I dive into the legal aspect of things, I'd love to introduce myself. My name, again, is Liz. Go figure. I moved to Juneau in 2005 with my now husband. A couple of years after that, that was directly after college, I left a couple of years later to attend law school in Vermont. Returning back to Juneau in 2010 and working for the state of Alaska. I worked mainly at the public defender's office and then for Department of Law. But after nearly 10 years, I knew I was ready for a change. Attorneys work a lot within conflict, but for me, it's not fun to work in conflict. And then I also knew that I wanted to work with people in more of a personal capacity than I had been doing. I started as a health coach, starting my own health coaching business in around 2017, 2018. And I realized how much I loved working with individuals on their particular health goals. And also I loved running the business. As I thought about then shifting though to the legal aspect, private practice in the law was not something I had ever been remotely interested in. So if I was going to start my own practice, I knew that I wanted to be very conscientious about the decisions I made, and that I wanted to do something differently than some of the common legal models out there. For one, I had been a client before, and I was really frustrated by the billable hour. When I asked the attorney I was working with a question, I didn't know if it was going to take them 10 minutes to find an answer or 10 hours. And I think the billable hour really puts a damper on relationship building. As a client, you don't want to ask any questions you think are not absolutely vital, because you know that any time spent with your attorney is going to be costly, or any time not even with them, but a simple email could cost. And then if your attorney starts engaging in any kind of chit chat, getting to know you, you may feel that they're more interested in making money than they are in actually hearing about you. I don't find that dynamic is good for attorneys or clients. Now, there are some legal areas where it's hard to get away from the billable hour. But you'll see that here at Liz Smith Law, we can avoid it. And then I knew I wanted to be conscious about the types of people I worked with and the type of work that I did, which is why I chose to focus on estate planning. As I got into the field, I asked friends and family about what experiences worked for them and what didn't. I have a friend whose father paid over $4,000 for his estate plan to make sure that his kids stayed out of court upon his death. And yet when he died, his kids spent multiple years in court. They even had to fight with his ex-wife. My friend thought it must be malpractice, only to ask around and learn that what the attorney did was actually common practice. On the contrary, my grandparents hired an attorney, and they met with that attorney regularly over many decades, making changes to their plan as their life circumstances changed. They also introduced their daughter to their attorney, my aunt, and the person who would later serve as their trustee upon their incapacity at death. This meant that my aunt knew the attorney when her parents died and had a relationship and trust built up when she turned to that attorney for guidance in handling the estate. It went relatively quickly and smoothly just a couple of years ago, and she stayed out of court. You will see and hear during this presentation more about how we do things differently here at Liz Smith Law, but just a few highlights. We only serve estate planning clients, plus we do the post-death administration when someone dies, and I work with a select number of businesses. This focus allows us to better serve our clients in these specific areas. We also do entirely flat fee billing. I guess there could be some exception, but generally with our estate plans and businesses. So if you work with us, you know what that fee is going to be. You can plan around it, and we can really get to know you. All of us at Liz Smith Law can get to know you and your family. We also have a team and systems in place. So if someone expresses interest in working with us, we're going to make sure that you get your plan in place and that it gets signed. It's all too common for someone to start working with an attorney on their estate plan and get hung up on a decision they're struggling to make. They never sign their documents, and the attorney doesn't follow up to make sure they get it taken care of. Even if you might be slightly unsure about a decision, some plan is probably better than nothing. Plus, we follow up on more than just the legal documents. We review ownership documents and beneficiaries to ensure that they make the most sense based on your plan. And if we agree together on recommendations to make changes, we're going to follow through and make sure that those changes are made and made correctly. We also offer a free review at least every 3 years so that your plan stays up to date with your life and the law. And we have very modestly priced membership programs starting at $325 a year that provide provide annual reviews and more. So we'll cover more about that near the end. On a more personal note, I'm married. Picture of my husband here on the screen. We have 2 lovely but aging dogs, and my main hobby outside of work is triathlon. We also love to travel. If you would like to share anything about you, I welcome you to do so in the chat. You can email or send a chat to everyone here. You can also choose my name if you would like, Liz Smith, and then Alex Weddle is here. She is a team member, and Alex Weddle, LSL. You'll know that you're messaging her, and she is a great resource to send your questions to if you want her to ask them at the end, or anything that you might want follow up on. While you do that, I want to make clear that while I am an attorney, I am not your attorney unless we have a written engagement agreement together. I will be sharing information today that is quite general. It is based on Alaska law and Alaska statutes, but not specific to your situation. If you are interested in getting more specific information, I will tell you how you can do that. And then what brought you here today? Did you come to get the total assurance and comfort knowing your family would be taken care of in the way you want if something happens to you? Did you come for the peace of mind, knowing what would happen to your assets at your death, or maybe to make sure that your family doesn't pay estate taxes unnecessarily? Or maybe you came to make sure that you'd be taken care of in the best way possible and that the best decisions would be made for you if you become incapacitated. These are all great reasons to be here today. You'll learn what you need to do to have the peace of mind, knowing you've made the right decisions for your family during your lifetime, so that at your death, things are as easy as possible for the people you love the most. So let's dive in and start by talking about the state's plan for you. That is what would happen if you have no plan in place at all. And that is most likely going to be called probate. Probate is the court's process to transfer the title of assets that are in your name at your death. If you have no will in place, then someone has to come forward to ask the court to be the personal representative. The personal representative is going to be responsible. It's one of the highest, it's a fiduciary duty. You have a lot of responsibility, and the court appoints the personal representative to essentially gather up your assets after death and then distribute to whomever is going to inherit. There are certain timelines that must be met. There are taxes that must be filed. It's a lot of paperwork. Someone needs to be organized to serve in that role. If you have no plan in place, the statute lists priorities of who can serve. So if you're married, your spouse would have priority. If there are adult children, they have what's called equal priority. So if they can all agree amongst themselves who would serve as personal representative, it's really very easy to get appointed. If they disagree, then they're going to have to argue in front of a judge who should be personal representative, and the judge would appoint somebody. You can think in your own life, who would step forward? Is it possible that your family might fight over the role? Is it possible that no one would be excited about it? It's a lot of work. Kind of depends on how much you're leaving, what's worth it for them. And then they may also have to post a bond. So there are times when someone might be willing to serve, but have trouble making that happen, getting appointed. Once the personal representative is appointed, usually I say that it takes, in theory, they could do probate within 6 months, but usually it's going to take 12 to 18 months at least, just because there is a lot of steps, a lot of work to do. The personal representative has to notify creditors. I mentioned some of the other things. It is also a public process. It's a lawsuit, and most lawsuits, all the court filings are open to the public. So anybody could go to the courthouse, get the file, look at who's going to inherit, and get some idea of what they're about to inherit, and just find out other personal information. They're going to see the entire will for sure, and then a lot of other information that gets filed with the court. It can also be an expensive process, depending on a variety of factors, but some of the things listed here are some of the fees: attorney's fees. The executor or personal representative can get paid for their time, any appraiser fees, filing fees, paying off the creditors. And then once the certain steps are done and everything is gathered into usually an estate bank account, then the personal representative can distribute the assets. And if there's no plan, then they're going to look at statutes and decide who's going to get what. And that may surprise you. If you are not married and have adult children, they'll all inherit equally. That probably doesn't surprise you. But if you are married and don't have any children and have living parents, your parents are entitled to part of the estate. If you're married and there are children from different relationships, so children that are not all joint children, then the children they do have a right to inherit at the first death. So it may mean that not everything goes to your spouse as you might intend or want. So there are some other you look at the statute, and again, it may surprise you what happens. And then if there are minor children that you leave behind after your death, they cannot inherit until they're 18. The court's going to name someone to handle their money. It can be used for the minor child, but then once they turn 18, they have full control and can do whatever they want with anything that you left behind. So that's a broad overview of probate. Here, the quote: a lawsuit you file against yourself with your own money for the benefit of creditors. Many people wish to avoid it. It's not the worst thing in the world, but depending on your circumstances and what your goals are, it may be something you want to avoid. Now, there are some people after their death, even if they have no plan in place, they can go through a different process, not have to file something in court officially, and do things a little bit easier, but certain conditions have to be met. So in Alaska, your loved ones will not go through probate if all 3 of these are met. If you do not own a house or any real property, so if you have real property, then this won't apply. If the vehicles you own are worth $100,000 or less, most people fit that. And then if the entire value of your assets are $50,000 or less, And in this last bullet point, we're talking about assets that would otherwise go through probate, meaning we are not talking about something like a life insurance account or retirement accounts if they have valid beneficiaries. So if there's a valid beneficiary, those assets are going to go straight to the beneficiary and wouldn't be counted in this 50,000. I'll also, while we're talking about beneficiaries, note that the beneficiary designation controls over anything else. So let's say you had updated your will, but if you're not looking at the beneficiary designations and you have an ex-spouse or an ex-partner, you've left out children, whatever it might be, that's going to control. So you want to keep regularly looking at your beneficiary designations. If you don't want to be stuck, your family to be stuck in the probate process, a will does not avoid probate. A fully funded living trust does, and we'll come back to some more details there. Quickly, I want to touch on estate taxes. If you have heard of them and you might be concerned about them, in Alaska, we do not have an estate tax. I will note that Oregon and Washington do. So if you have property out of state, or you might retire or move or retire to another state, it's something to consider. Here in Alaska, residents, we're only concerned about the federal estate tax. There is an exemption amount. Anyone who dies with assets under the estate tax exemption amount does not owe, the estate never pays estate tax. That exemption amount is changing constantly, and what matters is where it is upon your death. So it's something to monitor. Currently, it is historically exceptionally high at well over 12 million. So most people are not concerned today about it. However, it will come back down if the legislature does nothing to around 6 million in 2026. And the legislature can always make changes. So they could bring it down much lower than that. They could also decide to keep it quite high. It's something to pay attention to, though, because if your estate is over the exemption amount at death, the estate tax rate is very high. And there are planning tools that we can use, particularly if you're married. So it's something I like to look at for all clients. And the slide here is meant to show what we're looking at in terms of assets. We're just concerned with the equity value of anything that might have a loan on it, but it is going to include life insurance, retirement, business interest. So some of the things that might otherwise pass without probate may be subject to estate tax, or they will be. Okay, I covered a bit about the state's plan for you. What about a will and what about a trust? So a will, most people are familiar with, document that outlines your wishes. A will is great because it can keep your family out of conflict. Even if you have 3 or 2 adult children and they get along really well, it can be extremely helpful just to name who you want to be personal representative and then make clear what your wishes are. You have control with the will if you want children to inherit later, if you want to give, let's say, the family home to one particular child, etc. You get to decide what you want to happen. A will is perfect if you're not going to face probate anyway, based on your assets, could face probate. A will is a very important piece if you have minor children, to name guardians who you would want to raise your children if you were not able to. All right. So what about a living trust? A living trust, put very simply, is just an agreement. And that trust, if you think maybe like a business as an entity, a living trust is similar in that it is an entity and it can own things. So you transfer assets to be owned by the trust or name the trust as beneficiary. And by doing so, it allows you to keep your family out of conflict and to keep them out of court. That means it keeps everything private. Because you're not in court, the family can move at the speed that they choose. They don't have to wait certain timelines involved with probate. It can make things simpler, and it's also an easier way to make an estate more wholesome. Instead of doing things piece by piece, you can keep things at the end as more of a pot of money per se, that it can provide more flexibility in terms of dividing amongst your beneficiaries. You have more control, largely because of that last piece. It is, you can have lots of control in like a blended family situation, for example. It's easier to create a trust for beneficiaries starting with a living trust. And why might you want to create a trust after your death? First of all, for your children, if you didn't want them to inherit at 18, or if you have a beneficiary that might be bad at managing money or have substance abuse issues, you can name someone else to manage the assets for a child's benefit, and they can have the power, as much power as you want to give them. So you could name someone to invest assets for, let's say, an adult child's benefit. And if you have worries about substance abuse, you can say that the trustee has the power to require that they have a job, for example, or that they would have the power to say, you don't get any trust assets if you're using, and they could do drug testing. So whatever it is that you are concerned about or want to do is something that we can do with trust-based planning. And then by leaving assets in a trust after your death, you can also provide asset protection. That can include protecting assets from divorce and then other creditors as well. The living trust itself is not an asset protection tool. The living trust assets are seen just the same as your own assets, but you can then leave assets in a more protective way through a trust. You can also do some of these tools, some of the trust-based tools and the control after your death, you can do through a will, others you can't. If you have minor children, so one thing I did when I started in estate planning is found an excellent training program in basic estate planning, and then they help support our business throughout, or my business. I say we because we have a great team. And the mentor, Allie Katz, she started, when she started in her career as an estate planning attorney, she had her plan set up, had 2 young kids, was out to dinner with her husband, and she realized or started thinking what would happen on a really practical level if they got in an accident on the way home and didn't show up. The kids were with a babysitter. That babysitter was going to have no choice but to call the police. The police would come, and not knowing what else to do in the meantime, would put the children with the care of strangers in some type of custody situation. And so what Allie did was create a short-term guardian nomination or temporary guardian that would make sure that the babysitter had direction, so that they had a legal document that said these are the individuals that the parents would want to take custody in that very immediate emergency situation. So many of us have guardians we name that are out of state. They're even in those days following an accident. It could take some time for them to get there. So we make sure that there's short-term or temporary guardians nominated for our clients with minor children, and that paperwork is with both the temporary guardians and also with any babysitter or other caregiver. We have some free resources. We call it our Kids Protection Plan, the plan that we put together when there are minor children. And Alex has linked to some more information and some free resources. A couple of other things that I like to mention just so that you're aware of them if applicable. community property is a complex topic that I could spend a long time with clients and still kind of stumble through explaining. But I will tell you just what you need to know so that you can call us and ask questions or talk to your accountant so that you know if this is something you might want to consider. In Alaska, if you're married, you can choose to own property with your spouse as community property. What that means is complex. I'm not going to go into all the details, but what I will say is the result of owning property as community property is that if one spouse dies and the other spouse sells the property at some point later on, they may save a ton of money in capital gains taxes. So what I'll say is that if you're married, you plan to stay married, in other words, you think divorce is unlikely, and you have assets that have some appreciation, then it'd be recommended that you choose to own property in Alaska as community property. If you have other questions about that at the end of the presentation, I can go into a bit more as well. Maybe, or defer you depending on the question. What about long-term care? This is another consideration if you are aging yourself or have aging parents. And it's just an important conversation about what is it going to look like if you need care or if parents need care outside of the home or even in the home with a caregiver. If someone ends up in an assisted living home or a nursing home, the expenses are incredible and they can run out of assets very quickly, then turn to Medicaid for the care. But Medicaid's not going to cover a lot of other expenses like any kind of special care or grooming that you might need or snacks that you might want. Or I have family in assisted living home right now, but we still need another caregiver to do things that I can't do because I don't live there, like doing the shopping for kind of other things for them. So those expenses would not be covered. And there are ways that we can protect assets where you can still qualify for Medicaid. So good conversation. I usually say people 70 and older, just not too early to start thinking about it. And that is something we do in our office as well. Kind of the practice area is considered elder law, but that's a very broad range of what it can cover. And then incapacity, moving into if you couldn't make your own decisions, but you're alive, how can someone make decisions for you? If you've heard of a power of attorney or durable power of attorney, and then a healthcare power of attorney as well, two very important pieces. And I think that this is foundational, very essential, and something anybody 18 and over should have. Anybody can become incapacitated and need someone to make their decisions. The state provides free both healthcare agent document and a power of attorney. They are linked here, so no excuse. I recommend you do get them notarized. There's also an option for to have a witness as well. And this, of course, in our office, we do these for every client. I use a little bit different documents, but at the very least, I would say do it on your own and get them set. Now, why do it? So if you are healthy now, it'll take you maybe 10 minutes to fill out, and then you'll find someone to witness for you, go to your bank, get it notarized, take very little time and energy. If you don't do it and then you become incapacitated, then someone has to go to court and be named as guardian or conservator. That's likely to cost a significant amount of money. I mean, especially if an attorney is asked to help. It's also going to take an incredible amount of time. Courts are very backed up right now, and you're unlikely, in Southeast Alaska, you're unlikely to get a hearing for some months. I believe that up north, it is many more months. So it's going to take a lot of time. And then someone as guardian or conservator, a conservator manages the money, a guardian has broader powers. So a guardian would manage if you think of like what someone would do for a child, they have the power to decide housing, finances, things like that. So then that guardian or conservator, they have to file a report with the court on an annual basis, keep track of all the records. It's a lot. So that's the first. And then the second piece, of course, is choice. Who do you actually want to make those decisions? For some of us, it's clear who would make those decisions and kind of a no-brainer, but for other individuals, it may be less clear. You may be very adamant you want one child to make decisions. You may be a younger individual who doesn't have children or young children. And if you may not have a partner or spouse you would want to make decisions. And you may most definitely not want your parents to make decisions. So is there a trusted friend that you could name that could make decisions? So taking control, and then also not making your loved ones go through the court process to get named to make decisions for you. The last thing I want to ask you is if you had to choose between the people you love receiving your money or your values, insights, and stories and experiences, what would you choose? You don't have to choose, of course, but I believe that part of planning includes thinking about the overall legacy that you want to leave behind. There are lots of ways to share your experiences. For our clients, we offer a legacy interview for every client, a recorded interview to share your stories. And then my grandfather wrote his life story. You can write your own. There's a company called Storyworth that sends an email every week, and you just respond to the email. And by the end of a year, you can have your life story put together. It could be an easy way to do it. It's also a great gifting option for your loved ones. And I have a podcast. I did a podcast interview with Nimda Swart, who has a business about life stories as well. She's in Australia, but you can check out that podcast and her business. And the link is shared for you in the chat box. Or you can go to lizsmithlaw.com/podcast. And I think she's one of the first, or she's very early on. I think maybe number 2, my second interview. So you joined us this afternoon. That probably means that you're thinking about getting your own plan put together, or possibly looking for information for somebody else. Should you do it on your own or look for some assistance? And my thoughts are here. Of course, I am somewhat biased, but not just because I'm looking for clients. I also see how complex it can be. And many of the kind of DIY things that I see online, some are simply not going to work how the individual wants. But then other times the will might be great, but it might be missing some other pieces of the puzzle. So here's my thoughts. You can take them for what they are. But working with someone gives you the added assurance the people you love stay out of court and out of conflict. You don't get feedback with your estate plan. We don't know if it's going to work until you die. That can be comforting, but it also may be a reason you want to work with someone. And then if you want the people you love to have someone to turn to when something happens to you, this can be one of the most valuable things that getting a plan in place does. Is I offer family meetings, so I can meet adult children ahead of time, and they can start gaining that comfort to work with me if something happens to you, or when. There's just a lot of benefits from having someone that you work with. And I'll get to that question in just a moment. Sometimes it's easier to hire someone else to do your plan. I've met with people that have had it on their list for a long time. So just having someone work through that process with you. If you wanted to create a trust for whatever reason, I highly recommend working with someone to do that for you. It's more than just the document. There's a lot of follow-up and complexities. Unmarried couples, there's considerations. Blended families, there's a lot you can do through planning that an attorney can help guide you, any unique situation. With that said, there's some great resources on the court's website available for you here. And Alaska Legal Services has some as well. And Marge asks whether a trust versus a will make it easier for a personal representative to administer the estate. That is a great question. Both are going to make it easier because both a will and trust are going to spell out your wishes. With a will, of course, they're going to be in court. With a trust, it's actually a trustee. So whoever you name is going to be successor trustee. And generally, that's going to make it easier for them because they don't have the time for court. A trustee also can act upon your incapacity. And there are, if let's say you have a bank account owned by your trust, if you have a will-based plan and power of attorney, then your power of attorney could manage that bank account in theory upon your incapacity. Whereas if the account is owned by a trust, then your successor trustee would. And banks will often work more easily with the successor trustee than they would with a power of attorney. It's something that banks are often more comfortable with. So there's a lot more I could go into there. That's a great, important question. But if there's something really specific, let me know that I didn't cover. All right. You've heard a lot today, and I'd ask you to take a moment to consider what's most important to you. It's possible you were put at ease because you're comfortable with what would happen upon your death, or maybe you simply aren't too concerned since you won't be here. But maybe you think, well, I'd really like to provide asset protection for my children. Maybe you're not too sure about one of their spouses and you want to make sure that assets stay in your family. Maybe you'd like to control how and when your children inherit, especially for those of you with younger children. Or maybe you just want to avoid probate, whether that's because of the time that it takes, the cost of going through probate, or because you want to keep everything private. And there can be lots of reasons for privacy other than just kind of general privacy. If you wanted to disinherit someone, privacy can be really valuable. In probate, all of the heirs get notified. With a trust, if someone's not written into the trust, they don't have to be notified. And then I'd ask you to think about what your next step is. You took a great first step to get educated by coming here this afternoon. And what is next for you? If you're thinking, well, what would happen in my particular situation? Would my family end up in court? Would my children argue over who's going to be personal representative? Would your assets potentially be lost because your family simply doesn't know what accounts you have and where, and they may not figure it out? If you're thinking any of these things, I want to give you the opportunity to get answers specific to your situation. And that would be a life and legacy planning session with me. That's a 2-hour working session that we can do either virtually or in person in Juneau. If you're in another Southeast community, I travel a fair bit. I have trips coming up to Skagway, Wrangell, and Petersburg. So let us know if you would want in person if I might be traveling. During that life and legacy planning session, you share, excuse me, you share your family dynamics. And then I talk to you about the law. And together we look at what would really happen to the people you love if something happened to you. You then tell me about what about that works for you and what doesn't. And together in that 2-hour meeting, we could potentially choose the estate plan that would work best for your family from a cost perspective and an outcome perspective. So even if you think you're comfortable with what would happen, I invite you to take this next step to get the peace of mind knowing that you're comfortable. Normally that 2-hour meeting costs $750 because it's a 2-hour working meeting. But because you are here getting educated, and if you agree to do some homework ahead of time to gather all your assets, which is a critically important piece of the planning process and a first step, no matter if you go it alone or work with someone, I am willing to offer that meeting for free. And then additionally, as part of our role to move people forward, if you want to plan and get this done, if you schedule that life and legacy planning session with us today, and you decide during the meeting that you want to decide to work with us, then we will give $250 off your plan. If that life and legacy planning session is interesting and something you'd like to do, you can go to this link to book, and Alex will shortly put that in the chat box as well. You also, if you signed up, actually probably all of you should have received an email in your inbox with that link as well. All right. Now, if you decide that you want to do that later, that is fine, of course. We will still offer that initial meeting for free. You just need to let us know when you book that you were at a webinar. The $250 is only because it saves us time and energy following up with you after the webinar, and because I view it as my job to help you move forward. If you are planning with another individual, a partner or spouse, and may not be able to get their schedule before the end of today, you can go ahead and book. We allow one reschedule and still give you the $250 off. And then in terms of when to schedule, I recommend at least 2 weeks out, but you could schedule today as far out as is appropriate for you. And we do just the one reschedule because I have a few appointments, just a few slots available each week. And if I keep moving them, then we won't have a business. All right. Just quickly, I want to discuss what it's like to work with us at Liz Smith Law. I'm going to go through this pretty quickly because I know we're just in the lunch hour so that I can open it up for questions. But with us, you can schedule your appointment. Then we're going to send you a pre-meeting packet. Before we send you that packet, we're going to ask some questions. If we don't know the answers, like your mailing address, who you're planning with, we will either reach out by phone or we'll send you a form and ask you to fill it out and just submit that to us. Then we send the packet. You fill out your inventory. And we ask you to return that to us at least 3 days before your meeting. In that inventory, we're going to ask about your family. We're going to ask about what you have. You can fill it out pretty roughly, but doing it so is extremely important to your meeting. And we say that it usually is going to take 2 to 4 hours, depending on your circumstances. And then we'll have your life and legacy planning session, which I've gone through. And then if I'm usually about halfway through that 2-hour meeting, I'm going to ask if you'd like to plan. We're going to look at different options. And if you decide that you want to move forward and we both feel that there's a good fit, we can actually design your plan and then schedule a signing meeting about a month out if you're in Juneau. For our out-of-town clients, that's usually 5 or 6 weeks out. After your signing, we offer a legacy interview if that's something you'd like to do. And then we have one final meeting. And at that final meeting, we're going to go over your next steps. If we recommend you change, if you have a will and recommend change beneficiary, we cover it then. And then we go through just some other what's next, and that's when you actually get your documents at that meeting. And then follow-up's really important, and we are here to be your personal family lawyer for life. We offer those free reviews every 3 years at the very minimum, and then have a membership program with annual reviews for our clients. If you already have an old plan in place, we also do plan reviews. And that process can be slightly altered. But we're happy to talk you through what that would be for you. We do work with a number of legal insurance plans. If any of these are applicable to you, you can talk to your union and figure out how that works, or we may be able to help guide you as well. And thank you again. I'm going to stop the recording, open it up for questions. If you found this helpful and think someone else might enjoy listening, we will offer one shortly. I do them at least once a month, a bit more often as we move into fall and winter. And we will have the next time and date and registration information at lizsmithlaw.com/events very shortly.